Thomas, you may proceed with your closing arguments.
Thank you, Your Honor. Your Honor, Counsel, ladies and gentlemen, again, I want to thank you. I know we took up 2 full days and we thought we'd be done in 1. I apologize for keeping you so long, but you guys were very patient and many of you asked questions and you paid attention. I want to thank you for your this case is a breach of contract case, and my client is contracting with Rossi Construction to re-roof his home. And a copy of that contract's huge in here, and it's Exhibit B in your books. And my client knew nothing about roofing. I mean, doesn't know what proper ventilation is, doesn't know what a gutter apron is, has no knowledge about roofing. He relied on representations made by Chad Rossworm when he came out and met with him and told him, this is what we're going to do, this is how we're going to roof your home. And as you can tell, the home definitely needed, well, that's not the home, that's the garage, but the home and the garage definitely needed a new roof. Based on those representations made by him, and again, he wasn't offered additional ventilation, he wasn't offered a gutter apron, which the ventilation, I think, Sir Rossworm testified was $75 of that. I mean, you're paying $5,000 if your house needs more venting. You know, $75 isn't a lot of money to add up. No discussion that he needed an apron. There was in the contract that the deck wasn't sound or secure. $30 or $40 a sheet of wood to replace that. Work was performed, and sometime in June, my client contacted them with complaints. He had another roofer come out and inspect the roof and learned of all the different problems with the roof. I mean, he brought them out to look at the roof. He voiced his concerns, told them he wanted a new roof done, and they refused to do so. They told them it was cosmetic, that they could fix it right now, replace 3 or 4 shingles, and you know, that argument obviously got heated, as you all heard. So, what we're asking today is you find they're in breach of their contract, and you're going to get a jury instruction. The court's going to instruct you, and in order for Mr. Clark to recover damages from Rossi Construction, he must prove the following: that they entered into a contract which the parties did not dispute, that he performed his obligation of that contract, which he did. He paid Rossi Construction $5,000. That's not in dispute. That Rossi Construction failed to perform its part of the contract or performed it in a defective manner. And that's what we're alleging. We're alleging they performed their work in a defective manner, and obviously the defense is arguing that they did a perfect job, aside from some cosmetic things. That breach caused Mr. Clark damages, which were reasonably anticipated, and that Rossi should be responsible for those damages. And we're going to ask that you find they perform the work on the roof in a defective manner. And the standard, and we didn't talk about this in jury selection, but the standard is what's called a preponderance of the evidence. Okay? We're not in criminal court where someone's liberty is at stake, and here we're talking about money. And when we're talking about money, the standard of the preponderance of the evidence, the court's going to instruct you what that means, and essentially that means by the greater weight of the evidence. And the instruction you're going to get from the court simply is going to state evidence is of a greater weight if it convinces you more strongly of its truthfulness. It is evidence that convinces you that something is more probably true than not true. And a greater number of witnesses testifying to one fact on one side, or a greater quantity of evidence introduced on one side, does not amount to a greater weight of the evidence. So essentially, is it more likely not true than not true? And if you're looking at the scales of justice right there in the corner, in a criminal case, beyond a reasonable doubt, those scales have to come all the way down. But in the civil case, it could be a featherweight, more likely than not. And that's what Mr. Clark's burden of proof is. He's got to prove that it's more likely than not that they performed defective work on that roof and they were in breach of that contract. And if you look at the invoices from Century Roofing. That roofing company states that the roofing nails are sticking up and exposed. The roof decking is weak. Shingle exposure and nail location is inconsistent with manufacturer requirements. The ventilation of the house is inadequate. The gutter apron does not go into or behind the gutter. Poor workmanship. And they give a quote on what it would cost to fix the problem. And the quote in July 2008 is $9,609. And the quote in March of 2009, after the roof started to leak, is $10,570. And so we're asking, you find damages in amount between that, $9,609 and $10,570, and that's up to you based on those two estimates. Now, there's also an invoice from Century Roofing from prior to the work being performed. And that was the initial bid, and that was $5,834. And Rossi Construction's bid was $5,000. So you can see that there's been a substantial change from when Rossi did the job. Century Roofing's bid in October of 2007 to re-roof this home was $5,834. After Rossi Construction did the work in a defective manner, they came out 6 months later in July, and now it's going to cost $9,609 to fix the problems they found. So that's what we're asking for here today. We ask that you take time in looking at all the pictures. You can see for yourself. Looking at these pictures and looking at these pictures of the type of work they performed on the roof. And there's some talk that the shingles here are gray. I mean, you can look at the pictures yourself and see they're not gray. These are all brown shingles. There's some shading in certain parts of the pictures. I don't even know why they even tried to allege that these were gray shingles. I think that's an insult to you. It's an insult to Mr. Clark. But none of the shingles here are gray. None of these pictures are from prior to the work Rossi Construction did. All of them have a timestamp on the back of when they were printed at Walgreens. All the same date, July 24th, 2008. All are pictures of the roof after Rossi performed the work that they were supposed to do pursuant to that. I thank you. I'll pass it over the time. I'm going to give the opportunity, but I'm going to have the final say, and I'll have an opportunity to talk to you guys once more. Thank you.
Mr. Zuber.
Thank you very much, Your Honor.
Ladies and gentlemen, you've sat here patiently for 2 days, listened attentively, asked questions, and for that, both parties are extremely grateful to you. It's late. I'm sure you're all tired, so I'm going to keep my comments as short as possible. Now, you've heard all the evidence. You've probably heard as much or more than the parties and their attorneys. And now is the time for you to try to make sense of all this. In the next few minutes, I'm going to suggest 3 different ways that you can find on this evidence in favor of my client, Rossi Construction. Now, this was a very simple breach of contract case until we got to this afternoon, the rebuttal phase of the case where, I guess all hell broke loose and we started to get into evidence which probably has very little, if anything, to do with this case. But as counsel reminded you, this is a simple breach of contract case. The word breach means to break. In other words, a contract, well, everyone knows what a contract is. It's a bargain between 2 people. In this case, you exchange money, $5,000, for certain specified work. A breach of contract is a cause of action where the plaintiff is alleging that my client, Rossi Construction, broke their promise in the form of a contract. by doing something that they shouldn't have done. Now, it's a breach of contract case, and I think the evidence is very clear from the contract in the book that Rossi contracted to reshingle the roof in the garage. He did it. And Rossi agreed to remove and replace the existing roof vents and the pipe boots, and they did it. And Rossi agreed to install ice and water shield. We talked about that, what that is. And the evidence is they did it. Rossi agreed to remove and replace the gutters and the downspouts. Remember, for an extra $700. And Rossi did it. And they agreed to haul away all of the debris, and they did that too. Well, they didn't agree to install, adjust, replace the gutter apron. They didn't agree to replace any plywood decking. They didn't agree to install any additional vents. So you can decide, based on this evidence, that Rossi did everything that it said it would do. It didn't do any other work that it said it was going to do, but it didn't do. And you can find, based on that evidence, that Rossi didn't breach its contract, and on that basis find in favor of the defendant, Rossi Construction. So that's the first way you can decide this case. You can also decide that it was reasonable that Chad Rossmer, as a responsible businessman, after 6 months, came over to Mr. Clark's house and tried to respond to his complaints. And the counsel indicated that a confrontation resulted. He backed off to his car, wrote a letter the following day saying, if you want this work done, we'll be glad to do it. And apparently nothing came of that. Now, this is a breach of contract case, and counsel zeroed in on exactly the right instruction here. It's instruction number 3, and it has to do with what the plaintiff has to prove to you in order to recover in this case. And the converse of that, ladies and gentlemen, is if the plaintiff does not prove these elements to you, then your verdict must be for the defendant. And it goes like this. To recover damages from Rossi Construction, Dennis Clark must prove all the following by the greater weight of the evidence. Greater weight of the evidence. More probably true than not, just like counsel said. Number 1, parties entered into a contract. That's easy. Everyone agrees they entered into a contract. Number 2, Dennis Clark performed his part of the contract. Easy. Dennis Clark paid the $5,000. We accepted the $5,000. Everyone walked away. Thank you very much. But here's where it gets tricky. Number 3, Rossi Construction failed to perform its part of the contract or performed in a defective manner. One juror asked a very, very astute question. It said, and I paraphrase because I can't remember the exact words, has any contractor identified the source of the leak or attributed it to Rossi's breach of contract? Something like that. In fact, ladies and gentlemen, Mr. Clark admitted he knows very little about roofing. On the other hand, Mr. Washburn and Dave Curlin had 17 years or so of experience in roofing. And not once did you hear any evidence from a competent contractor that we did something wrong to cause a defect in this house. What is the evidence as to the source of this alleged leak? Well, we don't even know exactly when it started, let alone the source of the leak. We don't know if this is true. We don't know, based on this evidence, what, if anything, Rossi did in the contract which caused that leak. That's the problem. Whoever wrote the Century Roofing estimates did not testify. In the one estimate, he says it cost $5,800 to do what Rossi did for $5,000, and then a year later, now it's $10,000. $10,000 after now the house looks like this. Does that make any sense to you? The problem starts and stops when you think that there's no evidence as to what has caused these alleged problems with the plaintiff's house and garage. And even if we know what the source of those problems are, we don't have any information as to whether their breach of the contract caused those problems. There's even a third problem as well. Even if Mr. Clark had supplied evidence as to what was the source of the problem and whether it had anything to do with what Rossi did, how do you come up with damages? How do you come up with whatever money, if any, it would cost to remedy whatever problems he's complaining about? You don't know. And if you don't know, as the instructions will say, you can't guess or speculate. You can't just throw a head up in the air and it comes down with a number on it. That's not fair to Rossi. And one of the instructions will tell you you're not to base your damages on guess or speculation. If the plaintiff does not supply that evidence, you can't go back there and make it up. That's not right. It's not fair. So, that was the third element. Rossi Construction Company failed to perform its part of the bargain. Well, we did everything we were supposed to do, or performed in a defective manner. Well, who said any of this work was defective? At first, it seemed as if Mr. Clark was going to testify that he always had leaks in his house. And then, when he came back to the stand, he said, oh no, my leak started between the first and second estimate. Well, that was years after we found it. And whatever basis Century had to base their estimate, it's certainly not clear when his leak started. And remember, we have no photographs, none, showing this leak inside his house. Where is any documentation showing this leak? Where is there any evidence that he went out and hired a contractor to fix it? And this was 6 years ago. So we don't know exactly when it started. We don't know exactly we don't even know where the leak is in the house. And we certainly don't know whether that leak, if it exists, has anything to do with our work. Well, that doesn't sound like the plaintiff carried his burden of proof. In any case, that's the second way you can decide for Rossi Construction. Number one, they did what they said they were going to do. Or number two, that the plaintiff has not proven the case as to the source of the problems and whether it had anything to do with our work. So, if so, you have to find for the defendant. Now, there's also a second count. It's called breach of habitability. Counsel didn't spend much time on that. Breach of habitability simply means that somehow whatever we did in breach of contract made Mr. Clark's living conditions at the house less enjoyable. Well, we heard no evidence that Mr. Clark couldn't do everything he could do before we did the work in his house. He could do that. There's just no evidence that we breached, broke our warranty of habitability. Fancy legal talk for not being able to enjoy his house as he did before. Anyway, there's simply no evidence of that. There's a lot about the case as you look back that you will have to admit simply doesn't make any sense. And this is part of the plaintiff's burden of proof. They have to not only supply those elements of breach of contract that we just discussed, but they also have to present evidence of quality and quantity that makes sense to you. If you go back in that room and you start deliberating about this case, and you're all asking each other, well, I heard that, but that didn't make sense. Or I heard this, and that didn't make sense. What you're really saying, as you scratch your collective heads, is that the plaintiff has not fulfilled his burden of proof. He hasn't presented that evidence in front of you so that you can be fair to both parties. And if you find you don't have that evidence, your verdict has to be for the defendant. Such as, you're shown certain photographs from the beginning of the case. And the photographs all depict a grave road. And you know the roof's not gray, it's brown. The roof before was gray. So what photographs are you looking at? Who took those photographs? And more importantly, when were those photographs taken? And the answer is not the Walgreens stamp on the back of the photographs. That shows when the photograph was printed, not when they were taken. And there's been no proffer of evidence as to when they were taken. They're looking at when the photograph was printed. Well, that's not good enough. You all know the difference between gray and brown. And if you don't trust the photographs you're being shown, especially in one photograph where it showed a defective shingle, and you can see a picture of the same roof, I believe it's C3, where there's no such defective shingle. Well, what happened? Did we come back and fix it under the dim of night? I don't think so. Something's amiss. Something doesn't make sense. And more importantly, what you're really saying is the plaintiff does not carry his burden of proof. Does it make any sense if the plaintiff says, oh no, I saw them replace a piece of sheathing, a piece of decking? Well, what sense does that make? I mean, if we replace a piece of sheeting, then we can charge them for it. But Dave Kerwin honestly took the stand and said there was nothing wrong with the decking. And they could have charged him and replaced the perfectly good decking. They didn't do it. Even though in their interest, it would have been in their favor. Does that make any sense? What is the decking about? He said, oh no, you replaced a piece of the decking. And I think he said 3/4 instead of 1/2 inch. How did he know all this? Does that make any sense? Of course not. The water leak is the great mystery that we're all going to take away from this case. At first we thought, okay, after our job done, he's complaining about a leak, and yet there's no correspondence, there's no documentation. So the Better Business Bureau, there's not a word about the leak. And then when he takes the stand again, Mr. Clark says, oh no, the leak took place between the first and second incident. Well, when? And what, did he write a letter after he found out about the leak to Mr. Rossworm and say, okay, I got a leak now, do something about it? He's afraid of him? What, are cell phones not invented? You can't write a letter? You can't call it the Better Business Bureau? I mean, the only thing you can do is file a lawsuit? Does it sound to you, based on this evidence, that Mr. Rossworm was avoiding Mr. Clark, that he wouldn't have come out there and tried to make him happy if he knew about such a leak? Well, there's no evidence of the leak, ladies and gentlemen. You should demand more than Mr. Clark and you have to say, well, this leak took place sometime between this day and this day. You need more than that in order to decide this case. Well, those are the two ways you can decide this case. You can decide that Mr. Rossworm and Rossi Construction didn't breach their contract, or you can decide that the plaintiff simply has not produced sufficient evidence for you to decide that he's carried his burden of proof. You may have other questions about the case, and we should thoroughly discuss those. But when it comes down to it, this was a good job. This didn't produce any leak. Rossi produced and performed everything it said it was going to do. You pay for what you get. You don't get what you don't pay for. And a deal is a deal. If you find that Rossi Construction did everything they were supposed to do under the contract, and they did not, and you don't have any confident evidence to say one way or another whether his work is defective or not, and boy, that's true. There really has been no expert testimony in this case, one way or another, to say his work was not standard for the industry. And your verdict should be for the defendant. Now, this is the last time we get to talk to you, and I'm sure you have heard points about this case that we have not addressed. And Mr. Bagnellis gets one more opportunity to talk to you. But you know enough about this case so that when Mr. Bagnellis now talks to you, you can answer in your own head what he says does not make sense under this evidence, why your verdict should be for the defendant. Thank you very much.
Bagnellis?
Thank you, Your Honor. No, I still can't believe they're trying to say that these pictures, these tiles are gray. This one, that was the one in particular. So, you got up here again, so it's great. It shows you a picture. Taken from an angle far away, so they can't be the same height. This isn't great. I don't get it. But okay. All right. We want to say we didn't provide any evidence. There's invoices. Invoices submitted as evidence. They're actually submitted by the defendant as evidence. Roof nails sticking up and exposed. Roof decking is weak. Shingle exposure inconsistent with manufacturer requirements. Ventilation inadequate. Gutter apron does not go into or behind the gutter. All right. There's all this talk about the leak. He testified from the beginning, and I hope you took notes. He testified from the beginning. He didn't know of the leak until in between the second and third estimate from Century Roofing. That's never changed. He didn't change his testimony when he testified the second time. And why is leaking such a big issue? If the house doesn't have to leak for them to breach their contract. I mean, they can do the roofing job bad, and there can be no leaks. I mean, the leaking isn't the issue in this case. It's whether or not there are roofing nails exposed, which you'll see the pictures, whether or not the roofing deck is weak, and you have the invoice from Century Roofing, whether or not the shingle exposure is inconsistent with the manufacturer requirements, whether the ventilation of the house is inadequate, and whether or not the gator apron goes into and behind the gutter. Those are the things we're saying are defective. Whether or not there's a leak or not doesn't matter. Right? If they didn't put the roof on properly, and this is what it's going to cost to fix the problems they caused, Mr. Clark is entitled to that. In terms of I think the issue here is you have a very charismatic person like Mr. Rossworm, and he's, from watching him testify, I think he's more of a salesman. I don't think he knows a lot about roofing at all. And he goes out there and he wants to get his business. And it's winter time, so they're slow. And I'm sure not many people are roofing their house in the winter. And, he gives them the lowest price. And he tells Mr. Clark, I'm going to take care of everything. And, here's what the price is going to be. And, put down $2,500, pay another $2,500. And then he sends out people that know how to do a roof. He gives them the order. And maybe on his scope of work and on his order, he didn't put down things that the roof actually needed, like proper ventilation. When Dave testified, he testified that, I would have added ventilation to that home. Those were his words. But I have to follow what's in contract. And when I asked Mr. Casworm specifically, what are the manufacturer requirements for shingle exposure? His answer, 3 to 4 nails per shingle. When I asked Dave, his answer, 4 to 5 inches. When I asked Dave, if someone answered that 3 to 4 nails per shingle, do they know what they're talking about? Dave's answer, no. They don't know what they're talking about. So, the person giving the estimates doesn't know what he's talking about. And that comes from their own employee. And they didn't hire anyone to come out here and say they did the roofing job correct. All you have is their self-serving statements that they did it right. But we have estimates from a third party, Century Roofing, that show the work was done defective, and what we're asking you for is what's fair. He can't come back here again. This is his last day in court, his only chance. And, he paid $5,000 for a roofing job that was done defective. He just wants the money to fix it. Thank you.
At this time, because my duty is to instruct you as to the law, you apply to the facts and issues in this case. You are the sole trier of the facts, but you are bound to apply the law as given to you by the court. When you deliberate your verdict, you will have a copy of the final instructions and all the exhibits admitted into evidence. Bailiff, you want to pass out the final instructions to the jury? Ladies and gentlemen, you can be long if you wish, or you do not have to. A breach of contract occurs when 1. Party fails to perform all the duties it agreed to do, or 2. The party places itself in such a position that it is beyond its powers to perform the contract. Instruction number 2. To recover damages from Rossi Construction Company, Inc., Dennis Clark must prove all of the following by a greater weight of the evidence. 1. The parties entered into a contract. 2. Dennis Clark performed his part of the contract. 3. Rossi Construction, Inc. failed to perform its part of the contract or performed it in a defective manner. 4. Rossi Construction Company, Inc.'s breach of contract damaged Dennis Clark. 5. The parties reasonably anticipated those damages when they entered into the contract. And 6. Rossi Construction, Inc.'s breach of contract was a responsible cause of those damages. Number 3. The court's a party's conduct is legally responsible for a cause the property damage if 1. The property damage would not have occurred without the conduct, and 2. The property damage was a natural, probable, and foreseeable result of the conduct. This is called responsible cause. There can be more than one responsible cause for an injury. If you decide that Rossi Construction Company, Inc. has breached the contract, the measure of Dennis Clark's damages is the amount that would put Dennis Clark in the same position he would have been had the contract been fulfilled. Dennis Clark may only recover loss actually suffered and should not be placed in a better position than if Rossi Construction, Inc. had not breached the contract. Where construction defects are of such a character that they might easily be remedied without taking down and reconstructing any substantial portion of structure, the measure of damages is the reasonable cost of altering the defective parts so as to make them conform to the plans and specifications. Base your decision on the evidence and not on guess or speculation. However, damages need not be proven to a mathematical certainty. The implied warranty of fitness for habitation does not require that the dwelling be rendered totally uninhabitable before there is a breach of the warranty. A breach of implied warranty of habitability is established by proof of a defect of a nature which substantially impairs the enjoyment of the residents. As I said in my preliminary instructions, judges and jurors perform different tasks. I instructed you on the law at the start of this trial, and I will further instruct you on the law. You will decide the facts of this case, then you will decide the outcome of the case by applying all of my instructions to those facts. Do not base your verdict on sympathy, bias, or prejudice. Consider all of my preliminary and final instructions together. Do not single out any individual sentence, point, or instruction and ignore the others. The plaintiff, Dennis Clark, at Sue Rossi Construction, Inc. the defendant. Dennis Clark claims that Rossi Construction, Inc. breached its contract and workmanship warranty with him for the re-roofing of his home and garage. Dennis Clark also contends that Rossi Construction's failure to correct their nonconformance with the roof they installed caused damage to the interior of his home. Rossi Construction, Inc. denies Dennis Clark's claim. Rossi Construction, Inc. is not required to disprove Dennis Clark's claim. Rossi Construction, Inc. company has claimed certain defenses. Rossi Construction, Inc. must prove its defenses of failure to mitigate damages and acceptance of work by a greater weight of the evidence. Evidence of the greater weight is of the greater weight if it convinces you more strongly of its truthfulness. It is evidence that convinces you that something is more probably true than not true. A greater number of witnesses testifying to a fact on one side or a greater quantity of evidence introduced on one side does not necessarily amount to the greater weight of evidence. The parties in this case may prove a fact by one or two types of evidence: direct evidence or circumstantial evidence. Direct evidence is direct proof of a fact. Circumstantial evidence is indirect proof of a fact. For example, direct evidence that an animal ran in the snow might be testimony by someone who actually saw the animal run in the snow. On the other hand, circumstantial evidence that an animal ran in the snow might be testimony of someone who only saw the animal's tracks in the snow. It is not necessary that any fact be proved by direct evidence. You may consider both direct and circumstantial evidence as proof. You alone are the judges of the evidence, including the credibility of witnesses. Credibility means believability. A credible witness is a witness whose testimony you believe. In considering the testimony of any witness, you may take into account his or her ability and opportunity to observe what he or she has testified about, the manner and conduct of the witness while testifying, any interest, bias, or prejudice the witness may have, any relationship the witness may have with other witnesses or interested parties, and the reasonableness of the witness's testimony considered in light of all the evidence you have heard. Assume that each witness has testified truthfully. If you find conflicts in the evidence, reconcile those conflicts, if you can, based on the assumption that each witness has testified truthfully. Do not disregard the testimony of any witness without a reason and without careful consideration. If you find conflicting testimony that you cannot reconcile, decide what testimony you believe and what testimony you disbelieve. In deciding what or whom you believe, you should use your own knowledge, experience, and common sense gained from day-to-day living. A party may attack the credibility of a witness by showing that the witness made a statement or behaved in a manner inconsistent with the witness's testimony. You may consider the fact that the witness spoke or acted inconsistently with his testimony, in this case, only to determine the weight you will give to that witness's testimony given at this trial. However, if a witness testified inconsistently under oath, either in this case or any other case or court proceeding, you may also consider the content of the witness's prior inconsistent statement as evidence in this case. To return a verdict, you all must agree to it. In other words, it must be unanimous. Each of you must decide the case for yourself, but only after considering and discussing the evidence with each other. You should try to agree on a verdict if you can, to do so without compromising your individual judgment. Do not hesitate to re-examine your own views and change your mind if you believe you are wrong. But do not give up your honest belief just because other jurors may disagree, or just to end the deliberation. When you return to the jury room, select one of your members as a presiding juror to manage the deliberation. No one will be allowed to hear your discussion, and no recording will be made of what you say. The bailiff is available to assist you with personal needs, but cannot answer any questions about the case. If you have questions for me, you must put them in writing and give them to the bailiff, and I will respond as the law permits. You may be able to find answers to your questions by reviewing my written instructions and all the evidence. If at any time you are not all together, or if you are outside the jury room, you must not talk about the case among yourselves or with anyone else. I'm giving you possible forms of possible verdicts. The presiding juror must sign, date the verdict to which you all agree. Do not sign any verdict form for which there is not a unanimous agreement. When you have agreed upon a verdict, inform the bailiff. When the parties are present, the bailiff will bring you back into court, bring the verdict forms with you, signed and unsigned. At that time, I will read the verdict aloud. Each of you may be asked if it is your verdict. Otherwise, you are under no obligation to discuss your verdict or deliberations with anyone. Now, ladies and gentlemen, you may have noticed that we have a card on there so how you may try to conduct your deliberations in the electing of a presiding juror. All right. Okay. Mr. Bailiffs, I swear you in. Once again, you can swear the bailiff.
Didn't read the form of the verdict. Didn't read that one.
Raise your right hands. State your names. Do you solemnly swear or affirm that you will take the jury to a convenience place for deliberation, that you not communicate with them or yourself with regards to this case, or allow others to do so? Ask them if they have agreed upon a verdict, and they have done so. You will return them into open court, so help you God? I do. Oh, okay. All rise. You may escort the jury to deliberation. All right.